The $1.2 million mistake. How one senior NCO lost everything over one line in the sand. A 24-year decorated senior non-commissioned officer was one signature away from retiring with all his full benefits, despite the domestic violence and sexual offense allegations against him. The prosecution had agreed to a deal. His attorney had agreed to the deal. Now, he was going to do some jail time, but at the end of it, he was going to walk away with his full retirement intact. Millions of dollars, financial security for life. Then, his lawyer drew a line in the sand over one charge that had nothing to do with his retirement, and the whole deal collapsed. He went to trial, lost, got years in prison, and a bad conduct discharge that vaporized every penny of that retirement. I was the senior prosecutor in that case, and what I'm about to show you is the difference between defending your pride and defending what actually matters. If you're a senior NCO or an officer facing court-martial, you're about to make decisions that will echo for the rest of your life and for your family's life. The pressure to not give an inch, to refuse to admitting anything that feels unfair, to let your attorney fight every single issue, that pressure can cost you everything. Not because you're wrong to feel that way, but because the system does not care about your feelings. It cares about outcomes. And if you lose sight of your real priority in the heat of negotiations, you will lose the war trying to win a battle that never really mattered anyway. By the end of this video, you're going to understand a dangerous mistake people make when facing court-martial, and the simple mental framework that could save your career, your retirement, and your family's future. I'm going to walk you through a real case that the accused had everything on the table to keep his retirement and threw it away over something that had zero real impact on that goal. If you're watching this, you're probably in the fight of your life right now. Or you might be a loved one who knows somebody in the fight of their life. That person has given decades to the military. You've sacrificed time with your family, you've missed birthdays, deployed multiple times, led your troops through impossible situations, and now you're facing allegations that could take it all away in one fell swoop. Don't get me wrong, you want it all. You want to be found not guilty, you want your reputation back, you want the people to know the truth. I get it, but here's what people don't realize until it's too late. Wanting everything is how you lose everything. In military justice, you have to know your priority, that singular priority, and you have to protect it like your life depends on it, because guess what? It does. The case I'm going to tell you about still follows me today, not because I prosecuted lots of cases, but because the defense error in this particular case was 100% preventable. This senior NCO had 24 years in. He was a trusted leader, respected in his unit, and he had negotiated a deal that would have let him retire despite very serious domestic violence allegations and sex-related allegations. He was going to do time. He knew that, but his retirement was safe. Then the victim asked for one thing, one additional guilty plea to a charge that didn't add jail time, didn't put him on the sex offender registry, didn't change his legal exposure at all. It was symbolic to her. It only mattered emotionally. And that's where his defense counsel drew a line in the sand and threw a fit. Negotiations collapsed, they chose to go to trial, and he lost everything. Let me show you exactly how that happened and what it teaches all of us about strategy under pressure. Point 1, your client's priority should be the North Star, not your ego, not your principle, not fairness. In military justice, the only thing that matters is your client's true priority. And most defense attorneys lose sight of that the second their ego gets involved. This senior NCO had one job: keep his retirement. His lawyer had a different job: win the argument. Guess which one destroyed his life? In this case, the accused was 24 years into his service. Not just eligible to hit the button, he was over the 20-year mark. The only way he was walking away without his full retirement was if he got a punitive discharge from this court-martial. That's millions of dollars on the line, literally life-changing money. When we got into plea negotiations, it became crystal clear through every conversation, every email, every strategy session. His number one priority was keeping that retirement, not avoiding jail, not protecting his reputation, not being acquitted of every single charge. It was the retirement. That was his mission. And what's critical to understand is he had a deal that met that mission. The prosecution and defense were aligned. He was going to plead guilty to some of the charges against him. Others would be dismissed. Yes, he would do time in confinement, and a little more than he wanted. I mean, hell, nobody wants to do confinement time. But at the end of that, he would walk away on the other side and retire without a single loss of rank. He was guaranteed to retire as a senior NCO just like he wanted. The math worked, the strategy was sound. His priority was safe. But then the victim, his ex-wife, came back with another request after talking to her victim's counsel. She wanted him to plead guilty to one more crime. It was not a penetrative sex offense. It was not something that would put him on a sex registry. It didn't even add jail time. It was a charge that he paid her for sex during their marriage. To her, that one charge mattered. It was symbolic. It was an acknowledgement of something that had hurt her deeply. And his defense counsel lost it, threw a fit, called it unreasonable, said the government was moving the goalposts. And here's the thing. I get it. I understand the frustration. Negotiations are hard. Victims change their minds. It feels unfair to the defense. But you know what? Fair does not matter when you have a different priority. This charge that she added had nothing to do with whether he kept his retirement. Zero. It didn't move the needle on punitive discharge. It was emotional for the victim, and that's valid. But it was irrelevant to the accused's strategic plan. Instead of taking a breath, looking at the whole picture, stepping back, seeing the big picture for what it was, and saying, yeah, this sucks, but it doesn't impact our mission. Instead of doing that, the defense counsel in this case dug in, and the client followed. They refused, negotiations fell apart, and they rolled the dice on trial. Now, if you're facing a court-martial, your attorney's job is to protect your priority, not to win every argument, not to defend every principle, not to fight over things that don't really matter to your goal. And your job as the client is to be ruthlessly honest about what that priority actually is. If it's retirement, then every decision, every negotiated point, every strategic trade-off has to be measured against that standard. Does this help my retirement? Does this hurt my chances of keeping my retirement? If the answer is that it doesn't affect your retirement, then you bite the bullet and move on. Because pride is expensive, and in military justice, pride can cost you everything. Point 2, the victim's input is part of the system, and ignoring that reality is a strategic failure. In military cases, especially military sex offense cases, the victim's preferences are not just noise, they're legally required input. And if your defense strategy doesn't account for that, you're already losing. Your defense attorney can hate the victim's demands all he wants. But if he does not build a strategy that accounts for those, he's not defending you. He's defending his own ego. Under Article 6B of the Uniform Code of Military Justice, an alleged victim has the right to meaningfully consult with the prosecutor. Also under military law, convening authorities or special trial counsel, depending on the particular case, is required to consult with victims in some cases before approving a plea agreement. They don't have to do what the victim wants, but they do have to ask. Now, here's the problem. A lot of defense counsel treat victim input like it's an annoyance, a political box that has to be checked. Something the prosecution has to deal with, but not something that should affect their strategy as defense counsel. And that is a catastrophic misunderstanding of how military justice works today. If you or a loved one is facing court-martial today, you should not care about how the system used to be or how the system maybe should be. You and your lawyer should be focused only on how it actually works today. In this particular case, the alleged victim initially agreed with the supported deal. She was generally okay with the confinement range. But then she talked to her victim's counsel, someone whose whole job is to explain her rights and to help her understand the process. And she learned about something called good time. See, in the military, you get 5 days a month off of your sentence for good behavior. So if you're sentenced to 12 months, you're really doing closer to 10 months if you don't screw up. She did not understand that when she first agreed to the deal. But when she learned about good time and then did the math, she realized the confinement range that she had agreed to was not what she had thought it was. So she came back to the prosecution and said, I want a little bit more time. And I want him to plead guilty to one more charge, paying me for sex. Now, was that frustrating to the defense? Absolutely. Did it feel like goalposts were moving? Sure. But here's the reality. The convening authority usually will not agree to dismiss charges with a testifying victim and a strong case unless that alleged victim supports the deal. And if the victim says, I won't support this unless X happens, that's not the prosecution being unreasonable. That's the system working as it is currently designed. And this is where defense counsel have to be adults. You can hate the victim has a voice. You can think it's unfair. You can argue till you're blue in the face that it should not matter what she wants. But it does matter, legally, practically, and strategically. And if you build a defense plan that ignores that reality, you're setting your client up to lose. In this particular case, the defense counsel treated the victim's request like a personal attack on him. Like she should have known better, or like the prosecution was trying to sandbag the deal. But that is not what was happening. Instead, she learned more about the system and what the deal actually meant, something the defense counsel clearly understood when he was negotiating the deal. He just wanted her to be stuck with something she didn't understand at the time. If you're facing criminal allegations in the military and there's at least one alleged victim, you need to understand that that alleged victim is not just a witness. They are a stakeholder in this process. Their preferences will be considered. Their voice will be heard. And if your attorney is building a strategy that treats that like an obstacle instead of a known variable, you're in trouble. A good defense attorney does not ignore victim input. They anticipate it, they prepare for it, and they build flexibility into a negotiation so that when it comes, and let me tell you, it will come, that input will not blow up the whole deal. Because the goal, no matter how much you want it to be, the goal is not to beat the victim. Your goal should be to protect your priority. Point number 3. When you go to trial over the wrong hill, you don't just lose the battle, you lose the whole war. Now, this senior NCO refused to plead guilty to one charge that did not affect his retirement. So they went to trial. And he was convicted of more crimes than he would have pleaded guilty to in the deal that he turned down. He got years in prison, got reduced to an E4, and was given a bad conduct discharge. His retirement, poof, gone, all of it. His pride cost him $1.2 million. His pride or his attorney's pride, I don't know. Regardless, pride cost him $1.2 million. 24 years of honorable service, gone. No pension, no benefits, no financial security for his family, no medical care for him or his kids. The very thing he was trying to protect, the whole reason he was in negotiations in the first place, was destroyed. And I want you to sit with that for a second. He had a deal that would have let him retire. He would have done some time, yes, and he would have had to plead guilty to charges that felt unfair, probably. He would have had to swallow his pride and admit something that embarrassed him. But he would have walked out of that jail cell and collected a full retirement check every month for the rest of his life. Instead, he gambled on trial because he and his attorney could not let go of one charge that didn't matter to the mission. And he lost everything. Now, let me be clear. Going to trial may not be the wrong strategy. We go to trial a lot. Trial can be the right strategy. But if trial does not align with your priority, then it doesn't make sense. This is what I mean when I say you have to adjust fire. In the military, when you're shooting and you miss the target, you do not just keep firing in the same direction. You adjust, you recalibrate, you figure out what's working and what is not, and you change your approach. The same thing has to happen in court-martial strategy. When negotiations shift, when the battlefield changes, when the victim asks for something new, you do not just dig in and refuse to move. You stop, you reassess the situation, and you ask, does this change my ability to achieve my sole priority? If the answer is no, you adjust fire, you give a little bit, you take a deal, and you protect your mission. But that's not what happened in this case. The defense counsel convinced the client to get emotionally locked in. They drew a line in the sand over something that had zero strategic value. And they paid the price. Not in lost pride, not in hurt feelings, in years of freedom and millions of dollars of retirement benefits. If you do take your case to trial, you need to understand what you're risking. You're not just risking a guilty verdict on the charges you're fighting. You're risking everything. Now, that risk sometimes matters. That risk is sometimes the right choice. But again, it's very important for you to truly understand what is your priority, what is the strategic benefit to going to trial. And if that punitive discharge comes, whether it's a bad conduct discharge or dishonorable discharge for enlisted members, or dismissal for cadets, warrant officers, or commissioned officers, your retirement is over. Your career is over. Your family's financial future that you've planned and worked for is over. And you don't get a do-over. You don't get to go back and get that deal that used to be on the table. It's gone. So before you go to trial, you need to be absolutely certain that what you're fighting for is worth what you're risking. And that you've got the right team on your side. Importantly, if your retirement is the priority, it's the only fight worth having is one that protects that retirement. Everything else is just noise. Point 4, I want everything is not a strategy. It's a fantasy, and fantasies get destroyed in the courtroom. Okay, every client wants the same thing. Not guilty on all charges, no jail time, keep their retirement, no money lost, reputation intact, and have everyone apologize to you for doubting you. And to do so without spending too much money. Cool, that's called a fantasy. But in the real world, you don't get everything. You get your priority. And if you can't name your priority, you've already lost before the game has started. Let me show you what the real world looks like and what strategy actually looks like. I cannot tell you how many military members accused of crimes I've dealt with, either as a prosecutor or as a defense attorney, who come to the table with the same list of expectations. And if I were in their shoes, I'd want the same thing. That's human, that's normal, but that is not strategy. Because in military justice, especially in cases involving serious leaders or serious allegations, you almost never get everything. The system is designed to extract consequences. The prosecution has resources, the command has already made a decision to move forward, the alleged victim has rights, and the political pressure is real. And the math is simple. If you're already in the fight, you're going to pay something. The question is just, what is that payment? So the first thing I do with every client is to ask them to rank their priorities, not their wishes, their actual priorities. If you could only save one thing, what would it be? Is it retirement? Is it avoiding all jail time, no matter? Is it staying off a sex offender registry list? Is it maintaining your relationship with your kids? Is it keeping your security clearance so you can work in the defense industry after the military? Whatever your most important priority is, that is your North Star. That is the thing we build the entire strategy around. Everything else is negotiable. So let me give you some examples. If your priority is retirement, that means you might have to accept a reduction in rank. It might mean you have to spend some time in confinement. It might mean you have to plead guilty to charges that feel unfair or embarrassing. But if those things don't threaten your retirement, then you take that deal. You swallow your pride, you protect your mission. On the other hand, if your priority is avoiding jail time at all costs, maybe you've got young kids, maybe you've got aging parents who depend on you day in and day out. Maybe you just cannot psychologically handle the idea of confinement. Then you might have to give up the idea of retirement. You might have to accept a punitive discharge in exchange for a great deal with no confinement. That's a trade-off. It sucks. But if your priority is total freedom, that's the cost. In this case, the senior NCO had a clear priority: retirement. He said it, his lawyer said it, the prosecution knew it, and he had a deal that protected it. But when it came time to make that final trade-off, admitting one charge and doing just a little bit more jail time, neither of those affected his sole priority, and he couldn't do it because somewhere along the way, his priority shifted. It stopped being about retirement and started being about pride, about not letting the victim win, about not giving her an inch. And it's that shift that killed him. If you're facing a court-martial, sit down with your attorney today and answer this question. What is my number one priority? And I mean number one, singular, not your top three, not all of the above. One thing. Now, it's important to know what that one thing is. It is also important to have more than one priority because many decisions can be made with all three in mind. But at the end of the day, when things get tough, you really need to understand what that singular priority is, because at some point they will conflict. The thing that you must understand is that if you lost everything else, but you could live with that outcome, what is that priority? That single priority. That single priority is the one thing that if you lost everything else, but you kept that one thing, that is the one thing that you could live with as being the outcome. Once you name that single priority, every decision becomes simpler. Every negotiation point gets measured against that standard. Every risk gets weighed against that goal. And when the pressure comes, when the victim asks for something that contradicts one of your other priorities, when the prosecution makes you a counteroffer you don't like, when your attorney tells you the deal sucks, you know whether to fight or fold. Because you know what you're actually protecting. And trust me, that clarity is the difference between walking away with your life intact and losing everything over a battle that never mattered in the first place. Now, if you're watching this and you're facing court-martial, or you think you might be, you need to understand something. The decisions you make in the first month are decisions that will determine the outcome of your case. Not something that happens at trial, not the actual evidence. The strategy you build right now, before charges are preferred, before the Article 32 preliminary hearing, before you're locked into a timeline. That's when cases are won and lost. And if you're working with an attorney who doesn't understand how to build a strategy around your specific priority, and to do so before preferral of charges, you are already behind. Look, I've spent years on both sides of military justice as a senior prosecutor and a senior defense attorney, working with senior NCOs and officers who are in the fight of their lives. My job is to help you identify your true priority, build a strategic plan that protects it, and navigate the military justice system without letting ego, emotion, or pride destroy your future. Do not wait until it's too late. Find the right attorney now. Don't be the person who loses everything because they didn't have the right strategy in place from day one. Point 5, adjust fire. The most important thing your attorney probably will never tell you. In the military, when you're shooting at a target and you miss, you don't just keep firing in the same direction. You adjust, you recalibrate. The same thing has to happen in your court-martial strategy, but most defense attorneys are too proud to do that. If your defense strategy is not working and your attorney won't admit it and change course, you're not being defended, you're being led off a cliff. This is a phrase every single person in the military should know: adjust fire. It comes from artillery. When you're firing at your target and your rounds are not landing, they're going short or wide, you don't just keep shooting and hope for the best. You stop, you assess the conditions, you adjust your aim, and then you fire again. It's basic, it's common sense, and it applies to everything: tactics, leadership, logistics, and yes, even court-martial defense. My wife's guard unit calls it semper gumbi. It's the same principle. You cannot just charge full steam ahead without recognizing a shift in the battlefield. But here's what I've learned from years in military justice, both as a prosecutor and defense attorney. Most defense counsel don't know how to adjust fire. They get locked into a strategy early. We're going to fight every charge. This is all about self-defense. We're going to take it to trial. And then they ride that strategy straight into the ground, even when the battlefield changes, even when new evidence comes in, even when the victim's position changes, even when the convening authority signals that they're willing to accept something that matches with your priorities. The attorney's ego gets tied to the original plan and they cannot let it go. In this particular case, the original plan was solid. Negotiate a deal that saves retirement. Negotiate a deal that doesn't require reduction in rank. And the prosecution was willing. The defense was willing. The victim was willing. The client's priority was clear. That target was clear and legit. But then the victim came back with a request that changed the terms slightly and only added one additional charge and some more time. The smart move would have been to stop, step back, reassess the situation, and ask, does this change our ability to hit the target? And in this case, the answer was no. That charge did not affect retirement. It did not affect sex offender registry. So the right move was to adjust, take the deal, and protect the mission. But instead, the defense counsel treated the change like an insult, a personal insult, like the prosecution was cheating, like the victim was being unreasonable. And instead of adjusting fire, he doubled down. He refused, and he told his client to dig in. And they fired straight into the dirt, missing the target completely. And the consequences were catastrophic. Now, I want to be really clear about something. Adjusting fire does not mean giving up. Adjusting fire does not mean taking every single deal. It does not mean rolling over. It does not mean accepting every demand the prosecution makes. It means being strategic with your decisions when the battlefield shifts. It means knowing when to hold the line and when to give ground. It means constantly asking, is this fight getting me closer to my priority or further away? And if the answer is further away, you adjust your plan, you adjust your strategy. You do not let pride or principle or emotion drive you off course. If you're in the middle of a court-martial case, or if you're just starting to navigate a potential military justice case, pay attention to how your attorney responds when things change. Does he dig in and refuse to budge, even when the facts shift? Does he treat every prosecution move like a personal attack against him? Does he talk more about winning than about protecting your priority? If so, that's a red flag. A good defense is like a good fire direction officer. She is constantly assessing, adjusting, recalibrating to make sure you're still on target. And if your attorney can't do that, if he's too proud or too rigid to adapt to the battlefield shifts, you have a serious conversation that needs to be had. Because in military justice, the cost of missing your target isn't just losing a case. It's losing your career, your freedom, your retirement, and your family's future. And you don't get a second shot. Let me bring this home. The senior NCO in this case had everything on the table. He could have done some time, walked out, and retired with full benefits. Instead, he and his defense counsel drew a line in the sand over one charge that had nothing to do with his real priority. Negotiations collapsed. They went to trial. He was convicted on multiple charges, sentenced to years in confinement, and given a bad conduct discharge that vaporized his retirement. The lesson: keep your priority at the center of every decision you make. Not your pride, not your ego, not what feels fair, your actual, real-world, life or death priority. And when the battlefield shifts, guess what? It will. Adjust fire. Do not die on a hill that doesn't protect what actually matters most to you. If you're facing a court-martial, you are in the most high-stakes moment of your life. The decisions you make right now will determine whether you get to retire with dignity and financial security, or whether you lose everything you've spent decades building. And the thing that could kill you isn't the evidence, not the prosecution. It's losing sight of your priority and letting emotion drive strategy. Now, everything I just showed you assumes you have time to negotiate. But what if you don't? What if you already have charges referred and your attorney did not create the leverage for a deal? What if a deal it was never in the picture? What if you're headed to trial whether you like it or not? That's where my next video comes in, because there are different strategies when negotiation is off the table and you're in full combat mode. I'm going to show you exactly what that looks like and how to build a trial defense that doesn't just fight charges, but also protects you and your future, even if you lose. Now that you understand how losing sight of your priority can cost you everything, you need to know when you can't negotiate, when you're locked into trial and your only option is to fight. In my next video, I'll walk you through mistakes I see defense counsel make at trial over and over again, and the framework I use to protect my client's futures, even if the verdict might not go your way. If you or someone you love is headed to trial, that video could be the difference between just losing your trial and losing your life. Make sure you subscribe so you don't miss it.